Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a very interesting book which is highly topical at the moment, which has come to us from Ashgate Publishing Limited. Now this book has the title, it's a long title, Judgments of the European Court of Human Rights, with the subtitle Effects and Implementation. And it's been written by and edited by two people, and I hope I pronounce the names correctly, Anja Seibert-Fohr and Mark E. Villiger. Now, as I say, Ashgate have published this, and it's done in conjunction with studies of the Max Planck Institute in Luxembourg for international, European and regulatory procedural law. And the book is now also available, as many are, as an ebook. Do have a look at our review, which is in the journals and on the web. And this video clip, I hope, will assist getting some idea of the measure of where we are in the middle of 2015 after a general election success by the Conservative Party, which is leading to some suggestions that there will be imminent changes in the strength of a judgment from the European Court of Human Rights as it affects the common law here in this country. Obviously in the past many will know that it was purely persuasive. Now it seems to have effectively a binding effect. Elizabeth and I have looked at this, but we had a discussion about it, and we've given the review that we've written the following title: The Role of the European Court of Human Rights, Controversies and Conclusions, aired in a fascinating debate. Obviously it's not the end of the debate by any means, but it's one that's going to continue for some time. Let's have a look at the book. It's a hardback. There we go, there's the front, nice picture of Strasbourg there, you can see. You've also got the spine, there's nothing on the back. As I said, it's part of the NOMOS organisation as well, and it's also part of the MPI in Luxembourg, Max Planck Institute. Now the book itself, let's just have a look at the back of it. There is in fact no proper, no real index. There's a list of contributors right at the back, which is where you will get some information. But what you've effectively got is a standard text for academic work, which is footnotes at the bottom there, quite a lot of them. You can see again there is a little bit of numbering, no proper paragraph numbering as such, but there is a certain amount of numbering. If you go to the middle of the book again, you can see for each chapter you've got the footnote numbering at the bottom. But there isn't, it's basically body copy in terms of the text. This is the front of the book there, and you can see it's got a mention of the studies. This is volume 2 of these studies. They're edited overall by General Burkhard Hess, which is useful to know. Then you've got some details here, which is quite useful to find out about the where you can get the ebook version of the information with relevant detail. And then you've got a foreword by Hess, which sets out where, and the foreword was written in October 2014. Then there's a preface followed by the two authors and editors. Then there's the introduction and so forth, the actual contents, and it names the individuals who have written as contributors, and the details of the contributors, as I say, are at the back of the book. And then we go straight into current challenges in European multi-level human rights protection. Now I have to say right at the beginning, you see just the middle of the book, there's a lot of English which comes out of this, which is very much the part of modern words that we use, and some of the words may have slightly different meaning from the words we as lawyers in this country might possibly think they have. So do be aware of some of the words that are used, mainly because I think some of it is perhaps mixed in translation. However, I think the worth of the book overall is very important, because we are talking here about an issue which was a substantive issue in the general election campaign without any question of doubt in May 2015, and this issue is going to be with us for some time as the UK government decides what it's going to do with the whole concept of human rights in terms of a new bill, British Bill of Human Rights or British Bill of Rights, which would not necessarily repeal the Human Rights Act 1998, but probably extend it and change it in part. The word scrapping the Human Rights Act, very emotive, but in reality what we're talking about is much of what is in the current legislation will remain, but there may be some changes. Let's look at where the debate is today. This is what we say. The book's been published by Ashgate, and its constituent articles basically are the result of an international conference which was held in Gottingen University toward the end of 2013. So you saw from the preface that in fact the book was coming together at the end of 2014 and is now on the market in 2015. And the key topic, of course, is the European Court of Human Rights and the various related issues concerning that court. Many of them remain controversial, and they've loomed large throughout the European Union whenever the issue of human rights is discussed. Now, the matter of human rights, which I've discussed, mentioned here, with the need to define boundaries and arrive at correct or at least reasonable interpretations, has escalated into a major debate, certainly in the United Kingdom, where we, not to mention the Americans, are celebrating the 800th anniversary of Magna Carta, which was sealed in 1215. Now, recording this just a couple of days after Magna Carta was celebrated, and it marked, of course, the beginning of the end of absolute monarchical power in England, specifically, and therefore the tentative and fitful start of modern democracy and the development of a common law as we know it today. The next few centuries, of course, that followed, I'm looking now at the historic perspective, saw heroic and often horrific struggles to maintain the rights enshrined in Magna Carta, the Great Charter, which of course King John had revoked quite quickly afterwards, claiming he'd been coerced into signing, or rather sealing it. But of course his son did actually produce a new version, and that is what we really use today, or parts of it. The problem is, as I've indicated, Magna Carta in turn was annulled, rescinded, misapplied, then conveniently ignored, and even now when the document is venerated, whilst feared by dictatorial regimes everywhere, many of the basic tenets still come under threat from time to time. And you probably will gather even now that whilst it's not actually a religious document as such, it is so fundamental that it transcends even that as far as this country is concerned. Although you must bear in mind that the people responsible for writing it were, of course, clerics. Although they didn't necessarily, there's no way of proving this, actually add to the content, which appears to have come from the barons themselves. Anyway, with all of this in mind, it should come as no surprise to anyone that there are a lot of Brits out there who squeamish about any abrogation or abdication of sovereignty by any European court, including the ECHR. And the most interesting segment of the book is therefore, at least for our readership here, section 4 on what is called subsidiarity and the role of domestic courts. That means to say courts in individual member states of the EU in implementing European Court of Human Rights judgments. And subsidiarity, of course, is another newish word to a lot of people, but it has a very substantial meaning legally and in European law and politics. Of special interest, of course, are a number of articles, one of which is from Sir John Laws from the Court of Appeal Civil Division, and Derek Walton, the United Kingdom agent at the European Court of Human Rights. The first point, an actual article, is, "Are human rights undemocratic?" asked Laws, examining specific instances where this is or is not the case. "There is an imperative need," he says, "for a principled disavowal by the ECHR of primary decision maker. Without this disavowal, there is, quote, a failure to respect the courts of the member states as the primary safeguard of human rights. Making policy laws, concludes, is not the role of judges, it is the role of democratic governments. And if courts ignore that, he believes they lose faith and damage the rule of law." A very, obviously, very important precedent which he's setting there with his argument. In the article following this robust and what we think is absolutely correct stance, Derek Walton examines subsidiarity and the Brighton Declaration. And Walton points out that the principle of subsidiarity lies at the heart of this important conference which took place in April 2012, defining, embedding and reinforcing it by saying work is already underway on the longer-term future of the court, that's the European Court of Human Rights, that may further develop the way the principle applies. Well, we're actually waiting to see a bit of that at the moment. And in the words of its two editors, that's Anja Seibert-Fohr and Mark Villiger, this admirable book, which airs so many different and sometimes conflicting points of view, provides a fresh look at the relationship between national jurisdictions and the ECHR, because it really is about the role of the ECHR internationally and actually how far the member states themselves can go, hence the concept of subsidiarity, what subsists in fact within the member state itself. This then and the Gottingen conference from which it sprung have functioned as much needed initiatives in providing a highly respected forum for debate on vital human rights issues, which will ultimately affect everyone in the European Union and certainly the future of the EU itself. Because again, we're going through a turbulent time as I record this, with serious problems in Greece and an announcement shortly about when we have a referendum on membership of the EU in Britain. Let me conclude by saying that it's important to note that the book is the second volume in a new series entitled Studies of the Max Planck Institute, Luxembourg, for International, European and Regulatory Procedural Law. And it's published under the Nomos imprint of Ashgate, which I've indicated earlier. Ideally, it should be on the bookshelves of international lawyers and academics throughout the EU and beyond. And I think most politicians in this country should read it as well, because it actually tries to put into some semblance of rationality where we are at the moment. There's the book again, just opening it in the middle. The constellation of global and national courts, jurisdictional redundancy and interchange. You see the words being used here. It's a high style of English to start with. There are some various quotes. Judicial globalization and its diversity. There's a lot of stuff to get through, if I can put it as politely as that. But you then come on to issues such as subsidiarity, which is this particular article here, which I'll show you, because that really is the theme running through the book itself. Derek Walton's article again is just going through there. You see the name of the author, the contributor is on that side right at the top, and then the title the other side. And then you've got a variety of other extremely useful contributions to the debate. Now, I dare say that many people ignore this because they have their own particular agendas on which they want to operate. But I do feel that because we are really going to be at a turning point within the next 5 years up until 2020 as to where we're going with the future of human rights, certainly in Britain, and the way it develops within Europe, there's a lot to play for. There's also one other thing to play for, which I've said before right at the beginning in my remarks, and that is that we are not looking, the way some commentators are suggesting, at scrapping everything, getting rid of it all. That is not what's going to happen. I mentioned Magna Carta right at the beginning because that 800 years ago started us on the road that we've actually ended up with today. And what would be ideal, wouldn't it, would be to bring all the strands of views together, the United Nations Declaration on Human Rights, the European Convention on Human Rights, all the other things, bring it all together with something nice and modern that everyone could accept. But that's a bit of an ideal. I'd like to thank the two editors very much, and to Ashgate and Nomos for producing this book, and all the people involved as contributors. It's a fascinating debate and it's going to run. But thank you to all now. Bye-bye.